So in the previous lesson, we started to talk about the concept of procedural impropriety as one of the other grounds for judicial review. We noted that you can generally justify procedural impropriety as encompassing one of two major categories, i.e. failure to follow procedure which is laid down in statute, which is what we looked at in the previous lesson. And then the second point is failure to follow procedure that is laid down by the basic principles of natural justice. This lesson is going to think about those basic principles of natural justice. We'll talk about what natural justice is, some of the basic elements of natural justice, as well as a couple of cases that illustrate the point of natural justice as well in relation to judicial review. So, we'll examine the two main maxims of natural justice by which procedural fairness, or the converse obviously being procedural impropriety, has to adhere to. And like I said, we'll examine some key cases which illustrate these principles in more detail. So, simply put, the two main principles of natural justice are the following. I'm not going to try and read the Latin phraseology. Thankfully, we have translations to them. The first suggests that we should hear both sides of a case, and the second is that no person should be a judge in their own case. These are the basic principles of natural justice. So everybody has a right to be heard and a right to have their case be presented and a response to be presented. And then secondly, nobody should be a judge in their own case. So that a case ought to be judged by an independent body, an independent analysis. So, essentially, we can distill these two principles of natural justice down to, firstly, there ought to be a fair hearing, and secondly, there ought not to be any bias. There should be no bias within any particular case. And essentially, these are very wide principles. The scope of these principles are incredibly expansive, and given that, basic idea, it makes sense to suggest that the courts have had to grapple with these principles over the years and have spent some time dealing with and discussing and coming to grips with these basic principles and these basic conclusions. And really what I'm going to do for the rest of this lesson is just illustrate how the principles of natural justice have been laid down in various cases. The cases that I look at aren't by any means an exhaustive list of cases that we can think about. There are various different cases that we can look at. I've just found some of the most popular cases, some of the ones that are most cited in and around the textbooks, and are generally seen to be the most popular cases on this topic. And I'm going to begin here with the case of Ridge and Baldwin from 1964. This was a case in which a committee was attempting to remove a chief constable from a borough police force. So we have a committee that was trying to get rid of a chief constable from a police force. The officer had been arrested and had been charged with a conspiracy to obstruct the course of justice. So that was their sort of rationale for trying to remove them. They were arrested and charged with an offence, which of course doesn't look good if you are a chief constable in a police force. He would be acquitted of those charges, but the committee still attempted and were successful in dismissing him through the exercise of their authority under Section 1914 of the Municipal Corporations Act of 1882. Now, they did so without giving the constable any opportunity to present their case. So the question here is of natural justice, of the basic principle of the right to be heard. When this was challenged through judicial review on the basis of natural justice and procedural impropriety, it was held that by the Court of Appeal, it was held that such principles did not apply in situations in which there were administrative situations. The situations were administrative in nature. The House of Lords, however, would allow the appeal, noting that the Chief Constable ought to have an adequate information of the charges, as well as an opportunity to be heard in response to those charges. There's a bit of a back and forth here. Even though they did the acquitting or the dismissing, should I say, of the police officer under the provisions of statute, the Municipal Corporations Act. They didn't follow some of the basic principles of natural justice in doing so. And so as a result of which, the House of Lords held that the Chief Constable ought to have both adequate information of the charges as well as an opportunity to be heard in the case. It was argued that just because there was no clear definition of natural justice, it does not mean that one cannot conclude that it does not exist, or can conclude that it does not exist. So basically, one of the arguments that was had here and that was presented is that because natural justice is a vague principle, it doesn't really have any clear and definite descriptions, then it cannot be said to have applied. Obviously, this doesn't make any sense, as you would understand, and so the result here is that fundamentally, just because natural justice is a principle that does not have a clear definition, it does not mean that you cannot conclude that natural justice does not exist. This case also illustrates what some of the principles of natural justice actually are. And according to Lord Hodgson, there are three such principles of natural justice: a right to be heard, a right to notice of the charges, and a right to be heard in answer of those charges. So the first one is obviously the basic principle that you have a right to present a case in response to the charges that have been presented against you. You also have a right to notice of the charge. You also have a right to adequate notice of the charge. And you also have a right to be heard in answer of the charges that have been presented against you. A more recent case is from 2014. This is a case of A versus the BBC, and this goes all the way up to the Supreme Court. Now, what this case is illustrative of is that where there is actually a strict application of the constitutional principles of natural justice and the rule of law, in the circumstances in which there may be the creation of injustice, significant injustice, the court will have the ability to depart from such principles. So basically what it's saying here is, in certain circumstances, a strict application of natural justice might in fact bring about significant injustice in response, and in those circumstances the court will have the ability to depart from the principles. The principle that was at stake here was the basic principle of open justice, the idea of cases being public and cases having people being seen to have justice be done onto them and have justice applied to others on their behalf in an open and a visible manner for the entire public. We don't want this idea of there being secret trials that take place without anybody knowing, because obviously that wouldn't be particularly very democratic. And so what we have here is a case in which we have a convicted child sex offender. This is an individual who goes by the name of A. Obviously, their name is not published. They were a convicted child sex offender who were actually at risk of being deported back to his country of origin. The deportation order was challenged on the basis of Article 2 and Article 3 under the European Convention on Human Rights. There are Article 2 rights and there are Article 3 rights. Article 2 pertains to the right to life. Article 3 is the prohibition of cruel and inhuman treatment or punishment. Sorry, torture and inhuman treatment and punishment, essentially. These, of course, were justified on the basis that if this convicted child sex offender was to be deported back to his country of origin, that deportation order would likely have either caused death or torture or ill treatment or punishment to this individual on the basis of the general understanding of that country and knowledge of the country in which they were being deported back to. So the deportation order was challenged on the basis of protecting their Article 2 and Article 3 rights. He would seek judicial review under the upper tribunal's decision to deport him, at which point his name and address would be deleted for the purposes of anonymity. One of the really key and important things that needs to be noted here is that when we deal with cases involving child sex offenders, or where we're dealing with cases involving people who commit child abuse, murder of children, all these different kinds of things, There are human rights considerations to be had when it comes to publishing their name and their address, obviously because of the fact that these are particularly heinous crimes that are committed against children, and the United Kingdom has quite a significant, often people in the United Kingdom have a significant response to people who are child sex offenders, and there is quite a lot of violent backlash against them. And there are numerous occasions in which child sex offenders will have their name anonymized in order to protect their identity, in order to protect their rights. Either their right to life under the Human Rights Act, if we're talking in a domestic setting, or if we're talking about this deportation order, their Article 2 right to life under the ECHR. Basically the same principles. In addition to having their name and address deleted for the purposes of anonymity, the courts also sought to get an order under Section 11 of the Contempt of Court Act, which essentially meant that no media publication would be able to publish his name and address. This was, of course, something that would be challenged by the BBC. The BBC challenged this order on the ground that it broke the principles of natural justice and the idea of open justice, that it would go against the basic principle of open justice to not allow the publication of his name, the individual who was a convicted child sex offender. And so, as a result, they challenged this order. And so we see here an imbalance, or we see here a clash of principles. On the one hand, you have the basic principle of open justice, which would have led to his name and address being published, or at least his name. But then you have the challenge of that on the basis of his right to life and his right to, and his freedom from, should I say, torture and ill treatment. The Supreme Court sided with the order, at least for the insurance that there would not be the publication of his name. They held that there would be the insurance of the anonymity of A. And they justified this on the basis of human rights. And they said that, quote, where a conflict is between the media's rights under Article 10 and an unqualified right of some other party, such as the rights guaranteed by Articles 2, 3, and 6.1, there can be no derogation from the latter. So they noted here that there is obviously a clear indication of something of a hierarchy of rights, at least within the ECHR. This is something that has been known to be the case from the earliest days of convention jurisprudence. But it also noted here that where there is a conflict here between Article 10 and Article 2, 3, and 6.1, there cannot be a derogation from the latter in order to protect the rights of the former. In addition to this, where there is significant injustice that is going to be had from the application of basic principles of natural justice, we can derogate from basic principles of natural justice to ensure that an unjust outcome does not come into fruition.